Welcome back to the Friday Five for April 7th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. We're going to look at 5 questions from this week that came up in various consultations and meetings with clients. Short questions, short answers. Maybe it's something you've wondered about before in the past. And if you have any questions in the future, you can always shoot me an email or use the link in the description to submit questions for a future episode. Question number 1. Do I need a will if my husband has one and I don't? So in this case, the prospective client has a husband who's actually married before, still needs to update his will. However, she wanted to know, does she even need a will if he has a will? Isn't everything taken care of? So the short answer is, in this case, no. You do not need to just rely on your husband's will. You want to have your own. So you do need a will if you're in that person's shoes, because your inheritance will be very different than his. In the case where he had a family before, has children from that prior marriage, his will would distribute things very differently. Second of all, without a will, you're leaving the distribution of your estate to whatever your local rules say, and it may end up going to people that you're not intending it to. So just because your spouse has a will doesn't mean you don't have to have one. And that's why normally when couples come into my office, we would do wills for both of them at the same time. Question number 2 from that same client this week: can I just copy the will that my husband has? Now in this case, it would be a very dangerous tactic to do this because, again, he had a prior family, and that will and all the provisions then were tied to his prior family, children who were under 18. There was a testamentary trust that was built into that. So in that case, that will would not be appropriate for the client who was coming to me to get an estate plan done at this point, because those provisions are totally different, and frankly it was an old will that had old provisions that needed to be updated anyway. So a lot of times people will come to me and say, can I just make a copy of X, Y, or Z? Whether it's in the wills realm, whether it's we're dealing with a business and I want to just copy the LLC agreement from my friend. The point is, you don't want to just copy from somebody else. You want to make sure that whether it's a will, whether it's a business document, that you are getting a document tailored to you. Don't go to some website and just mail merge your information into a form that they give you, because it might not be the right form and it might not be what you truly need. Question number 3 this week: where should I keep my estate planning documents? This is one of my favorite parts of consultations with new estate planning clients. So for those who don't know, back in the day, it would be very common for your attorney to keep the original of your will in their office in a safe. There's still plenty of attorneys who do it. Now, the reason they would do it is because when you die, your family has to go to the attorney's office, get the original copy of the will, and while they're there, sit down, have a cup of coffee. By the way, you probably don't want to deal with probate, so if you want to hire our office like your deceased family member did, we can take care of all the probate for you. It was a great marketing scheme for attorneys, a great way to get a little additional business. But the problem in this situation is, what if something happens to you and you need access to your documents quickly? You can't do that if they're locked away in a safe in your attorney's office and it's a Saturday and there's something going on. So when people ask me where should they put their estate planning documents, keep them at home, keep them somewhere safe, and keep the originals where you can access them, especially when it comes to powers of attorney. If something happens to you and we need to get access to them, we need to know where those documents are. Where you don't put them is a safe deposit box. So if you put them in a safe deposit box and you die, your family can't just go to the bank and get a copy of get the documents out of your safe deposit box, because it's going to take a court order. Once the bank finds out somebody has died, they lock down the assets until the court tells them what to do next. So under no circumstances should you be putting these documents in your safe deposit box, because you're just creating a problem down the road for your family members. Question 4 this week: what do I do if a debt collector is contacting my business? So in this case, the client is dealing with a rather aggressive debt collector. It's in the retail space, and they are getting emails, they're getting letters, they're getting phone calls. It's getting really obnoxious. And it's more obnoxious than normal because they're dealing with a business debt, not a personal debt. And when you're dealing with a business debt, the rules are relaxed. They're not the same as the Federal Debt Collection Practice Act. So the debt collectors have a little more leeway. They'll be a little bit more aggressive. And so in this situation, we mapped out a 3-part plan, and actually there'll be a video on this next week on the channel about this. First of all was to make sure you're communicating in writing. Second of all, you want to see if you can negotiate the debt. And third of all, open all the letters. Don't just let all these collection emails and letters pile up. You want to at least open them up and read them so you can figure out what's being said and make sure you're not missing any important deadlines. And then question number 5, actually also from that same client, is when do I need an operating agreement for my LLC? So I think of the old saying that when's the best time to plant a tree, and that is 20 years ago, and when's the next best time to plant a tree, and that's today. So if you've been operating your LLC without an operating agreement for years, maybe months, maybe you just started, now is a good time to make sure you have an operating agreement in place. You want to make sure you have all of this laid out so that your business looks legitimate. If you end up in a lawsuit, you can show the court that you're a legitimate LLC. We don't want to pierce the corporate veil. It's a legitimate business. If you're going to take on investors in the future, they want to see an LLC agreement. And frankly, they don't want to see one that was drafted the week before they contacted you or the week before the closing. They want to see that you're a business that has everything put together. You have your operating agreement, your contracts, all your other notices in place, so they know they're investing in a strong business with a good foundation. So when should you do your operating agreement? You should do it now if you haven't already done it. So those are our 5 questions from this week. There's a link in the description for asking questions for future episodes. If you found this helpful, I'd love it if you hit the like button. You can subscribe to the channel for more videos. It's Easter weekend, so if you're celebrating, I hope you have a wonderful weekend. It's finally getting warmer here in Minnesota, and hopefully spring is on the way. Have a great weekend.